So just one more video on statutory interpretation, because really the entire understanding you'll get of criminal law will come from statutes. We're going to focus on Pennsylvania, but we could choose any jurisdiction, or we could choose a hodgepodge of jurisdictions to bring in the important different concepts. And there are times when we will look at other jurisdictions as well. But there are many things that are different about criminal statutes than civil statutes. In your contracts class, you've probably seen the Uniform Commercial Code. Or in your torts class, you've probably heard of the restatement of torts. Or in your torts class, you've probably heard of the restatement of torts. In criminal law, we have talked about in the last video the model penal code, this proposed uniform code that law professors came up with in the 60s, much like a bunch of law professors came up with the restatement of torts or the Uniform Commercial Code. There is no uniform understanding of the right way to define and punish crime. Because unlike torts and contracts, criminal law is inherently political. And you obviously see debates about criminal justice reform that kind of are cyclical. There are times when society wants to punish more. In the 90s, we were in that mode. We're now in a world where there is a great deal of pushback to some of the very harsh punishment that was created by the federal sentencing guidelines, among other things that happened in the 1990s. And so that operates at the national level, but at the state level, different state legislatures will adopt different types of definitions of crime. We saw in the last video that most states have a hodgepodge of common law derived statutes and MPC derived statutes. But one way to go about looking at what the language that a particular legislature meant, or what was meant by a particular legislature when they enacted a particular statute, is to ask, where did this language come from? Not just did it come from MPC language, or did it come from common law language? Ask whether there are other states that have similar language defining this particular crime. So let's say that Pennsylvania has a statute that has an identical counterpart in Montana. So the interpretation by a Montana judge of an identical set of language is relevant to understanding what possibly Pennsylvania means by this. By the same token, if North Carolina has a very different statute and the North Carolina court says, we do it very differently than states that have this other language that Pennsylvania, say, has, then we can learn from those courts what's likely meant by Pennsylvania's language. Another thought, let's say that there's language that defines murder in one Pennsylvania statute, and there's similar language that defines assault in another Pennsylvania statute. Well, a Pennsylvania court's interpretation of that other language, of that same language defining another crime, is going to be helpful for understanding that language in the context of homicide. It won't be conclusive, because a statute that defines homicide may well have different purposes and be aimed at different types of conduct than one that defines assault, but possibly and probably not. You'll want to look at whether something different is going on, whether there are reasons to think that there are different motivations. But it is the case that if you have an interpretation of the same language in one place and another, that's a starting point for getting a handle on what that language means. So as you come to interpret these criminal statutes, because there is such a diversity of language in criminal statutes across the country, but also because there are only so many different ways these things can be defined, you're going to find that there are different places from which you can draw helpful authority. Sometimes it'll be within the same jurisdiction, but not always. So the criminal law will provide, because it has so many different variations, and because the politics of crime is so much more real than it is for the politics of contract law. That's, that no one ever gets elected to office on their theory of contract law, but they very much do on the theory of, on their view of criminal justice. So as you go through these cases and these statutes, we'll often flag for you other interpretations in other states, and know that in real life, you'll need to be thinking about what other people are doing, and figure out whether your legislature was on the same page with them or not, and be able to draw lessons and inferences from what others are doing, whether it's similar or dissimilar.